So, David, when a non-immigrant or an immigrant visa is done, the primary beneficiary is usually accompanied by the spouse and children. Are there some special considerations for the spouse and children?
There are, Vijay, and thank you so much for asking that question because that is a great one. But before I get into that, I just want to say namaste, adab, sat sri akal, and kemcho to all our listeners today. And with that, we'll get into, as you can see, I'm chipper and excited this morning because I got a national interest waiver case approved for a very high level executive, and he is absolutely ecstatic.
Congratulations.
Well, thank you so much. He is beyond ecstatic. And the first thing he asked me about is, what about my children? And he's especially concerned because he has a child who's turning 21 years of age. And obviously this approval for him is going to be relevant because his son, who's turning 21, is going to need to be concerned about getting his status before he turns 21, unless, of course, he can be preserved under the Child Status Protection Act, but that's another story altogether. But for us as immigration lawyers, we do a holistic analysis whenever we do our cases. And what we do is we look at the situation for not just the primary beneficiary, who's the individual who may be going to work for an organization, but we also look at the derivatives. And it's so important to look at the derivatives, the spouse and the children, if there are children, or if there is a spouse. And the reason why is because, from an HR perspective, we know that transfers only work when the family is happy and they're all together. Mm-hmm. So that's an HR perspective on making sure that the derivatives or the spouse and children are taken care of. But, what we have to do is we have to analyze each particular category separately. So, for example, if we're doing H's, we have to make sure that the spouse who would take an H-4 or the children who would also take H-4s, are they going to work in the U.S.? And if they're going to work, then we have to be guided by the possibility of making sure that their I-140s are going to get approved so the H-4s are in a situation where they can work. If we're talking about L's, these individuals, their derivatives are actually work authorized incident to their status. And I want to say it's a fairly new development, but I would say it's about a year old now, where you get work authorization incident to status for at least the derivative spouse, not necessarily the children. And that's the same for the E-visa. So when you consider the transfer, when you consider the need to do a visa, whether it be a non-immigrant visa or an immigrant visa, it's very, very important to take into account the needs of the family as a whole. Mm-hmm. So it's not just the individual who's transferring, but the whole family that needs to be considered.
Yeah, that's a great insight right there, looking at the family in the entirety for immigration. That's NPZ law. David Knockman, your one-stop shop for all things the A to Z of US and Canadian immigration matters. Don't hesitate to reach out to them today, and you can do that by logging on to visasearch.ca.